All right, the first case is Ogmulgee EMC versus McDuffie. This case, the matter was the employer's burden for suspension of benefits. Briefly, the facts were that the employee had a prior knee injury before working for the employer, then he had a subsequent accident. Next slide. Can you get it? There we go. He had an injury at work. After having the injury at work, the employer found out about his prior knee injury. They immediately suspended benefits. Then he went out of work, had surgery. They recommenced benefits. But once he returned to his pre-aggravation state, they suspended benefits again. So the issue was it lawful for them to suspend the benefits? Or do they have to keep paying if they haven't returned to their pre-aggravation state? The court held no. When an employee has a pre-existing condition that limits the workability, as soon as the effect of the work injury case ceases, essentially they return to their pre-aggravation state, you can suspend benefits. We're having technical difficulties. Here, go ahead and start talking about it. There we go. All right. Next case.
The next case we have is Chandler Telecom versus Burdett. We all know this case is willful misconduct. It has our friend essentially controlled dissenting, I guess you can call it. Controlled dissent after ignoring his supervisor's instructions to climb down. The issue is, does an employee ignoring the supervisor's instruction constitute willful misconduct so as to result in denial? The court had, it's possible. Essentially, no compensation is allowed for an injury due to the employee's willful misconduct. Violating the rules and obviously dangerous, hazardous acts alone are not sufficient for willful misconduct. Willful misconduct they did define willful misconduct. It's intentionally doing something either with knowledge that it's likely to result in serious injury or with a wanton and reckless disregard of probable consequences.
Of course, that leaves a lot of gray area, but it is somewhat defined.
I apologize.
Oh, we missed one. Here we go. Next case, Sanchez v. Carter. This is a dependency benefits case. So here there was an injury that resulted in a death. The claimant lived with somebody, but they were not married and they were not wholly dependent on them for living expenses. Or they were, wholly dependent on them for living expenses. The issue was, is the dependent who is not married to the deceased employee entitled to dependency benefits? And the Supreme Court says, nope. They denied the dependency benefits for actual dependent who is not married to the employee. Now, of note, this is different for children. There can be children who are not a product of the marriage that can be held as dependent, but you have to be married in order to get dependency benefits, just FYI.
And Georgia no longer recognizes common law.
No, they don't. Georgia definitely does not recognize common law. I'm sure some of you feel like doing this to some people sometimes.
The next case we have is Kendrick versus SRA Track. This is in the Georgia Appellate Court. The subject matter was continuous employment. I think this also goes along with our telecommunication policy, because essentially we need to define what is continuous employment and when does that end. The issue was also a controversy, was it timely filed? The employee essentially was living in Georgia, traveling to Alabama. So during the week, he would work in Alabama, but he would travel sometimes on the weekends. He was injured on Sunday about 4 o'clock while traveling to Alabama. Also, just going to the controversial portion of it, the employer was providing medications and medical benefits, and they had did it for several months. So the employer controverted the claim after the employee requested a hearing. The issue was, did the employer timely controvert, and was the employee in the employer's continuous employment when injured? The court had regard to compensation, yes. Where compensation is being paid, the controvert must be filed within 60 days. However, the issue was, what does compensation mean? Compensation in this regard was only weekly income benefits, not medical benefits. So yes, we can controvert, essentially when they're not receiving compensation benefits. The issue for continuous employment was no. An employee was required to work away from home during the work week, and he was off duty and traveling on the weekend. Continuous employment did not apply. However, it would apply if he was going to his job like maybe Monday morning.
All right, another continuous employment, similar yet different, as in all law, it seems. So on this one, and I feel like this one comes up all the time now, so the employer's providing a hotel room for somebody who's working out of town, because it's just cheaper to keep them, wherever they are that they're working, because they're working a distance from home. So on the weekend, while they're staying in the hotel room, the employee goes out doing something fun and injures himself on a personal errand on Sunday. The question is the injury on a personal errand compensable under the theory of continuous employment? Well, no, of course not. You're doing something personal, was what the court held. So if you're working away from home while you're working, you are on the clock and it can be a job injury. If you deviate from your employment to do something personal, no such luck.
This was Hope's copy.
That was mine. The racy ones are mine.
The next case we have is Cartersville City Schools versus Johnson. This one goes back to our idiopathic injury, and I think I'm still confused, I'll be honest. Essentially, the court overruled the previous case where it almost had the same exact facts. I think she was a nurse and she was turning to get a bottle of water for the patient. So essentially, they overturned that case, which was, I believe the name was St. John. They overturned that case. But the facts of this one was the claimant was in a classroom, she was instructing her students. She turned from her computer and she suffered a knee injury. The issue is an injury idiopathic when one is engaged in the behaviors and movements required by the job? The court held no. If someone is engaging in movements required by the judge and injured as a result of that movement, then it's not idiopathic. The key is determining what is required by the judge.
The job.
I'm sorry, the job.
And the judge. They make the final say. It doesn't matter.
The court concluded that idiopathy refers to injuries sustained at work that are unrelated to and do not occur while engaged in work. And actually, they also said if it has no causal connection. So they did go back to that, even though they overruled the case, but they went back to the causal connection. And if it's a causal connection to the workplace, then it's not idiopathic.
I think the idiopathic window is getting smaller and smaller and smaller to prove and define, in my opinion, in Georgia law. I mean, cases like this, got a couple of recent ones, and it just seems like they're slowly trying to get rid of it altogether.
Aren't they feeling that?
They are.
All right, that's it, unless anybody has any questions that we can maybe answer and look really smart.